Thank you for staying with us. Following the decision of the Electoral Tribunal, which was upheld by the Court of Appeal on the outcome of the March the 18th election in Kano, the state governor, Abba Yusuf, has vowed to reclaim his mandate at the Supreme Court in Nigeria. The governor, who was sacked by the Electoral Tribunal and the Court of Appeal, showed total dissatisfaction by the judgment. The appeal court sitting in Abuja on Friday upheld the ruling of the tribunal that sacked Abba Yusuf and declared Nasiru Gawuna of the All Progressives Congress the winner of the March the 18th election. Mr. Abba Yusuf has now instructed his legal team to challenge the appeal court's ruling at the Supreme Court. Joining us via Zoom from Abuja to discuss more on this development is General Secretary, Nigeria Law Society lawyer Abdulkadir Sani. Thank you for joining us on TVC Breakfast. Now, the governor who have been, said to be sacked by the Electoral Tribunal has said that this matter is a miscarriage of justice and that the court did not look at the merit of the evidence put before it. How do you interpret this judgment and what's your reaction, basically?
Well, you see, as much as the governor feels that way, I believe a lot of people also feel that in Kano. Not only in Kano, I think even people who have been following the development feel that the appeal court decision might have been a miscarriage of justice. First of all, if you remember, part of the judgment delivered, has to do with the intra-party activities, especially the qualification of Governor Abba Yusuf. And then you see, it has been a standing position of the jurisprudence that when a matter has to do with issue of membership, it sounds more of an intra-activity of the party, which an election tribunal should not have, reason to upset. And then you see, if you look at the light of decision of the Tinubu OB, I think the decision of Abba Yusuf appears to be, something different from that particular standing. So people are talking, and then I believe, just like the governor has said, is a miscarriage of justice, he still has one more opportunity to contest that judgment before the Supreme Court. And I think whatever the Supreme Court finally decides will give people a final resting position as to whether those issues, he claimed to be miscarriage of justice are indeed miscarriage of justice. But you see, if you look at the judgment in itself, as lawyers, of course, will abide by every pronouncement made by a court of law. And then we have something that is called stare decisis, that is judicial precedents. If you go by judicial precedent, I think you will come to understand that there appear to be a perceived conflict issue. So challenging it before the Supreme Court will definitely
All right. Would definitely get back to Abdulkadir Sani as soon as we can, but his position... Can you hear me?
I can hear you loud and clear. I can hear you.
Okay, so we did not get your last point on the matter of the governor taking the matter to the Supreme Court. If you could just re-emphasize that again.
Okay, well, I said, you see, as a litigant, when you go before a court of law and a court delivers judgment, either for or against, you will always have your reaction. And then Governor Abba Yusuf has expressed that there has been miscarriage of justice, and then he has instructed his legal team to proceed before the Supreme Court. Now, the decision by the Supreme Court will clear the dust, in the air, so that people will know whether, his assertions are right or wrong. Of course, I have, mentioned earlier that there appears to be a standing position of the Court of Appeal on issue that borders on affairs, internal affairs of a party. And then if the governor feels the law, as it is, as pronounced by the Court of Appeal, has gone contrary to the norms, I think he has chosen the right path to go and challenge it before the Supreme Court. The Supreme Court will decide whether or not it is indeed a miscarriage of justice. That is the point I've made.
Right.
Okay, but well, two things for me. Well, let's just quickly, confirm your position on this fact that yes, it may be a party affair, but everyone is subject to the Constitution that has already spoken on the issue of a valid nomination and sponsorship of candidates by political parties, which was what the Court of Appeal in this case predicated its judgment on. How do you correspond,
Yes.
that with your earlier remarks?
Okay, you see, my position on that, my view is the fact that going by the decision in Tinubu and Obi, I think that issue is an intra-party affairs, which ordinarily the lower court shouldn't have delved into it. But you see, they came up with a pronouncement, and I'm saying that that pronouncement, as affirmed by the Court of Appeal, appears and will be perceived by every legal-minded person who has been following the development and the jurisprudence in the country. We can say that I think it's an aberration of the earlier decision that was made by the Court of Appeal. And I think the Supreme Court would do justice to that if I give it a canvas in the right line to say that when a matter is an intra-affair of a party, of course, no one goes into it. A number of these, if you look at the case of Lawan and Machina, you see, you have a precedent, contrary to what it used to be, that a party who did not even perform, who did not participate in the primaries, was later declared to be a winner of an election. So I think the Supreme Court would also do justice to this, to come up with a finding that, yes, whether the earlier decision made, the position of the law has been contravened by this particular judgment delivered in Governor Abba Yusuf's petition. So that is my take. Personally, I feel that it's an intra affair of a party which a court of law ought not to disturb.
Okay, so let's get your position on this matter because there's been a number of sacking of opposition parties now, talking about that of Plateau State, Zamfara and Kano, and there are those calling the president to rein in on the activities of the appeals court, saying that the judgments are seemingly being controversial as it is, and that if the president does not, speak to these issues, it might just affect the confidence reposed on the judiciary by the people.
Well, to be honest with you, I will differ on people who are calling that the president should intercede in this matter, because the president's intercession in this matter will simply mean that the judiciary has no mind of its own. The judiciary ought to do what is right. We know we have people who are learned, we have senior lawyers in the country who are following all these activities. And then I will agree with you, and I will agree with every person who is saying that lately there appears to have been controversial decisions. That is very correct. It's very, very correct. You see, the beauty of the law is that when you have a judicial precedent, every lawyer approaching the court canvass arguments.
All right. I would have loved for us to get his perspective on this matter of controversial judgments by the appeal court, where he is also supporting that it's been controversial. But as the matter of the president reining in means that the judiciary has no mind of its own, which is very important. They have to be independent as it is. But how this whole matters will go, because there's been so much controversy and conversation around this recent sacking of these governors by the appeals court, how it is that we are seeing divergent interpretations to the matters put before the tribunal, and then the appeals also speaking to those issues. We'll see in the coming days how things will pan out and be addressed, but it's left to be seen how much impact this will have on the
overall,
the confidence reposed on the judiciary.
Absolutely.
Right. Okay, we'll have to let our guest go now so that we can quickly move on to our next conversation. But we must thank you, General Secretary, Nigeria Law Society, as well as a lawyer, Abdul Kadir Asani, for your time on the program. Thank you very much.